It's the new year. I hope you've had a wonderful holiday with the people you love. As for me, it's time to answer the last questions asked by $3 supporters at Patreon and Subscribestar in 2023. If you'd like to ask a question for January of 2024, the links are below. Let's start out on Subscribestar this time, where Dickin Myanus asks, since I could not find a way to custom tip monthly on this platform, can you add a $20 tier with the same benefits as the $5 one? I'm gonna put this out there. Both supporters and non-supporters, what do you think? It doesn't seem like Patreon and Subscribestar allow custom tips, so is this a good idea or would it turn people off? Tips are relatively easy to do at donate.bogosity.tv using PayPal, Venmo, and cryptocurrency, but I get that if you've already set something up at Patreon, you might want to use that instead of having to give another site your credit card information. On the other hand, I feel awkward saying, hey, here's a $20 tier, but there's nothing special. But I don't really know what I could offer that's worth that much. If anyone has any ideas, please comment. Also, let me know if you saw this on someone's page, what would you think? Would you see it as a convenient way to tip? Or would you think it's just someone wanting more money for not doing anything special? Let me know. FunwithFacts asks, hi Shane, what are some ways you think we could reform the American judicial system to make it less partisan? Gotta love the big questions. Might want to strap in for this one. I think we need to start out by recognizing that the Federalists were just wrong with this, and the Anti-Federalists had it absolutely right. In Federalist number 78, Alexander Hamilton wrote, the executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. And yet we've seen and are seeing right now in a major way that neither of those are true. In New York, Judge Engeron fined Donald Trump just for publicly complaining about his staff, a protected First Amendment activity. He even ignored the law to do it. The law says a judge can only issue a sanction up to a maximum of $1,000, but he fined him $5,000 and later on an additional $10,000. So they absolutely have the power of the purse. They also have the power of the sword. They can put you in prison for contempt, freeze your money, and even seize your assets. We've seen more than one case where the Seventh Amendment right to a jury in all civil matters over $20 was ignored, with the judges entering summary judgment with the defense having no opportunity to present their side of the case. Judges also get away with venue shopping, like in the Douglas Mackey case. It's in the Eastern District of New York, which covers Brooklyn and Queens, full of a jury pool that was instantly biased against him, as was the judge. Mackey has no ties to anyone or anything in this district, and no complaints or witnesses were from the district. But very valid motions to change venue were denied by the biased judge. The judge wouldn't even accept the jury's hung verdict. He kept hammering them and punishing them until they finally came back with a guilty verdict. The jurors voting not guilty finally caving so they could finally go home. Mackey was sentenced to 7 months in prison for posting a meme. Biden afterwards bragged that they could go on and do this to all of their political opposition. An absolute war on the First Amendment, waged by judges. That's the power of the sword. Consider also the fact that the decision on whether or not a biased judge should recuse themselves rests with the judge and is one of the few decisions not available for appellate review. Ironically, an unbiased judge might, anyway, to avoid the appearance of impropriety, which is supposed to be of paramount importance. But biased judges just say, nah, I'm keeping the case. So what can we do about it? Short of amending the Constitution, there are really only two things. One is to elect people willing to issue articles of impeachment against them. Judges can be impeached, not just the president. Also, although people think that federal judges are appointed for life, Article 3 actually says they're appointed for the duration of good behavior. And as far back as 1790, Congress passed a law making judges automatically ineligible for continued service upon conviction of a crime. Makes it pretty laughable, therefore, that Hamilton said, "If, then, the courts of justice are to be considered as the bulwarks of a limited constitution against legislative encroachments, this constitution will afford a strong argument for the permanent tenure of judicial offices, since nothing will contribute so much as this to that independent spirit in the judges which must be essential to the faithful performance of so arduous a duty." We can easily see why people should have listened to Brutus in the Anti-Federalist Papers. Every body of men invested with office are tenacious of power. They feel interested, and hence it has become a kind of maxim to hand down their offices with all its rights and privileges unimpaired to their successors. The same principle will influence them to extend their power and increase their rights. This of itself will operate strongly on the courts to give such a meaning to the Constitution in all cases where it can possibly be done as will enlarge the sphere of their own authority. Every extension of the power of the general legislature, as well as of the judicial powers, will increase the powers of the courts, and the dignity and importance of the judges will be in proportion to the extent and magnitude of the powers they exercise. When the courts will have a precedent before them of a court which extended its jurisdiction in opposition to an act of the legislature, is it not to be expected that they will extend theirs, especially when there is nothing in the Constitution expressly against it, and they are authorized to construe its meaning and are not under any control? This power in the judicial will enable them to mold the government into almost any shape they please. Perhaps nothing could have been better conceived to facilitate the abolition of the state governments than the Constitution of the judicial. They will be able to extend the limits of the general government gradually and by insensible degrees. One adjudication will form a precedent to the next, and this to a following one. In this situation, the general legislature might pass one law after another, extending the general and abridging the state jurisdictions, and to sanction their proceedings would have a course of decisions of the judicial, to whom the Constitution has committed the power of explaining the Constitution. If the states remonstrated, the constitutional mode of deciding upon the validity of the law is with the Supreme Court, and neither people, nor state legislatures, nor the general legislature can remove them or reverse their decrees. A constitution is a compact of a people with their rulers. If the rulers break the compact, the people have a right and ought to remove them and do themselves justice. But in order to enable them to do this with the greater facility, those whom the people choose at stated periods should have the power in the last resort to determine the sense of the compact. If they determine contrary to the understanding of the people, an appeal will lie to the people at the period when the rulers are to be elected, and they will have it in their power to remedy the evil. But when this power is lodged in the hands of men independent of the people and of their representatives, and who are not constitutionally accountable for their opinions, no way is left to control them but with a high hand and an outstretched arm. Thomas Urbanski just gives us all a shout out of Happy New Year. Back at you, Thomas, and to everyone out there as well. Over on Patreon, Darth Vega has a similar sentiment and also requests that I respond to a Ray Comfort video. Stay tuned for that. DeltaWolf asks, so after watching your previous AMA about plea deals and having gone through it myself, I can safely come to the conclusion that prosecutors and district attorneys should be abandoned and viewed as an archaic form of justice alongside the Inquisition. So my question then is, in your personal view, what would serve as the alternative? Should the police have to hire an attorney out of pocket to prove guilt, or the judge? I think you should have prosecutors set up like defense attorneys, different firms that people can hire. The police can hire them when they've investigated and are ready to make an arrest, and victims could hire them as well. I also think there's a case for the loser to pay costs. Restitution can be a lot more effective than punishment and can help make the victim whole while also offsetting the cost of the investigation. On the other hand, a losing prosecution would have to cover the defendant for the time and loss of liberty the arrest and trial comprises. As it is now, in either case, it can only be done through a subsequent civil trial, which adds significant expense and will only be allowed in certain extreme cases. Doing it this way would help make sure that prosecutions are only made against people where there's a good case against them, would discourage overcharging and the usual threats made on defendants, and would also give guilty defendants an incentive to go ahead and pay restitution rather than face the expense of a losing trial. Finally, Sid Padmanaban asks, what's the best response to the argument many make about private schools and the claims that they're a continuation of segregation? It's just a terrible argument from the start. First of all, segregation was a problem of government schools, not private. Also, private schools have proven to be far better for minorities. First of all, it's a complete myth that there's a lack of diversity in private schools. They've kept up very well with the population, in fact, including increasing proportions of Latino students as their numbers overtake African Americans. The biggest burden to them is the fact that their parents are still taxed to pay for the government schools, leaving it so fewer poor families can afford it absent scholarships. We know the solutions to this, though: vouchers, educational tax credits, a money follows the child policy, and increasing charter and magnet schools. Guess what people on the left are against? Anyway, study after study has shown that poor and minority students do better in private, charter, and magnet schools, even when various other factors are controlled for. I really don't know how to respond to something this blatantly false, other than just to say that it's blatantly false. Of course, the burden of proof is on the claimant, and they haven't done anything to prove it. They've just asserted it and backed it up with emotional bullying. And that'll close the door on 2023. I'm looking forward to all of your questions for this year. Until then, comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell, and check out other videos on my channel and like and share them to get them above the shadow banning. And of course, go to donate.bogosity.tv for all sorts of ways to support, including PayPal, Venmo, and various cryptocurrencies. Thanks again, and until next time, stay strong and be free.